Armed with hundreds of cut and pasted complaints and boilerplate discovery motions, Strike 3 floods this courthouse and others around the country with lawsuits smacking of extortion. It treats this court not as a citadel of justice, but as an ATM. Its feigned desire for legal process masks what it really seeks: for the court to oversee a high-tech shakedown. This court declines. In accordance with the accompanying memorandum, the court denies plaintiff's motion for discovery prior to a Rule 26F conference. Since this makes prosecuting this suit impossible, the court denies a motion for an extension of time and dismisses the case without prejudice. There is a lot said here, so please bear with me. We're going to go over this a little bit at a time. So this is a Strike 3 Holdings case, and Strike 3 Holdings is a company that prosecutes copyright infringement through BitTorrent file sharing networks. And yours truly makes part of his living defending people who are accused of this kind of file sharing from this company and other companies. Now, they have accused a John Doe, and they've included an IP address, and we are in the District of Columbia. We are in DC. So why a John Doe? Well, the way this works is they see alleged infringements on a BitTorrent file sharing swarm, it would be called in legal terms, and the IP addresses are logged, allegedly. I have seen some of this with my own eyes, but I also haven't been able to cross-examine their expert witness in court. I was not able to, my client settled their case before we've ever been able to get one of these expert witnesses up for cross-examination. Another attorney did, and I got to watch that, but I didn't get to do it myself. So I still would like to withhold a little bit and say that I don't know if these allegations are true, especially not in any one case, but even generally speaking, it's not easy to say what they have or don't have. The judge has written a memorandum opinion, and we're going to go over that next. The court has denied a motion by the plaintiff. Plaintiff's motion was for discovery prior to a Rule 26F conference. Well, that means nothing to you unless you're a lawyer and you know, actually, even if you're a lawyer, you might not practice and know what a Rule 26F conference is. In the Federal Rules of Civil Procedure, Rule 26 is a rule that requires this conference between the parties after an answer to the complaint has been made, and prior to the seeking of discovery. Rule 26 conference basically starts the discovery phase of trial in federal court. And so what if you don't know who the defendant is? How do you ask for an IP address to be tied to a subscriber without accusing a person by name? So you have to ask the court for permission to send a subpoena outside of the discovery phase of trial. You are literally out of order. You know, when the judge, everybody gets unruly in the courtroom and the judge bangs his gavel or her gavel and goes, out of order, or whatever, order in the court. That's what's happening here, is we are literally out of order, out of the procedural order of the court. And so the plaintiff has to go to court after filing a complaint and before being able to do anything with it, ask the judge for permission to send a subpoena to the internet service provider and find out who the subscriber is behind the IP address. The judge has denied this motion for permission to send this subpoena, which means that no one will ever know who John Doe is, which means the suit is impossible. And so the court denies a motion for extension of time to effectuate service, because how could you serve a John Doe, and then dismisses the case without prejudice. Now, this suit is remarkable because I haven't seen it before, but I'm going to guess that I've seen it before. This is the complaint, and the complaint is usually a bare bones allegation about, here we'll turn the highlighter on again, about wholesale copyright infringement, critically acclaimed adult motion pictures by these production companies, And then they accuse the defendant of stealing these works. However, defendant is an IP address, or should I say a subscriber assigned an IP address. So defendant being a subscriber assigned an IP address, how do you know that subscriber is defendant? Follow me on this one. Without anything more, how do you know that there aren't 100 people, 1,000 people, or one person behind a public-facing IP address on a cable modem or FiOS card, etc., etc., etc.? You have one or two, sometimes public-facing IP addresses that represent your whole internet connection for everyone using your internet connection. And if you're a family of 4, a person of 1, or a business, you're going to have multiple people behind an IP address. Even I have friends that visit and will ask, hey, can I use your Wi-Fi so I don't have to use my data? It sometimes becomes a little less frequent now that we're 12 years into the smartphone revolution, but it still happens. And so what if somebody uses that for infringing activity? All of a sudden, I'm subject to this lawsuit, and I, the subscriber, am being called the defendant here. Then they go on to say that this BitTorrent protocol is used, defendant is committing rampant and wholesale copyright infringement. They go over jurisdiction and venue, but we're not terribly worried about that. Award-winning copyrights, defendant used BitTorrent. They go a little bit into how BitTorrent works. Plaintiff's investigator, IPP International. Oh, I don't know if you remember, we went over this with the Christopher Lynch story, where they were using shell companies as their investigator. Well, look at this. They've challenged one of these Strike 3 Holdings cases with a motion for a more definite statement, used Christopher Lynch's declaration about what his investigation found about shell companies being used to make plaintiff's investigator look like it was from the United States, when in fact plaintiff's investigator is IPP International, which we all know is in Germany, I believe it is. If you've been following these kinds of stories or these kinds of cases, that's a huge revelation that Strike 3 is now openly admitting they're using the same investigator as Malibu Media, basically doing cut and paste or cookie cutter cases. So then they make an allegation of direct copyright infringement. They say that defendant downloaded stuff and that digital media files have been verified, but notice in here there is nothing showing which person behind an IP address would be the defendant. They don't have to know them by name, but there's nothing in here that says our investigation has concluded that the infringer is likely a young man in his 20s or 30s, probably with a college degree related to technology, who likes anime and Game of Thrones. And we think that if there is a person behind this that fits, we'll send a subpoena to the subscriber asking for them to reveal the name of the person that fits that profile, or to deny that a person fits that profile at all under oath. And then they get to decide. They're not doing anything like that. They're making this bare bones allegation of just saying defendant did it. Well, the general rules of pleading in a federal civil case. These are the federal rules of civil procedure. So you must make a short and plain statement on the grounds for the court's jurisdiction and relief and the types of relief sought. So you have to put out the basic claim of that you're making. You don't have to go farther than that. The pleading standard is extremely low. You just have to put the defendant on notice of what claims are being brought. Well, going back here, which defendant? Which person behind an IP address is being accused? You guys don't know anything more right now, and I'm intentionally doing this to you. You don't understand what's going on here yet. If you see this IP address, how many people are behind it? And which one of them is the likely infringer? Have you met even a basic pleading standard at this point? Well, a judge has said no. Strike 3 Holdings LLC produces, quote, award-winning, critically acclaimed adult motion pictures. Strike 3 is also a copyright troll. Its swarms of lawyers hound people who allegedly watch their content through BitTorrent, an online service enabling anonymous users to share videos despite their copyright protection. Since BitTorrent masks users' identities, Strike 3 can only identify an infringing IP address using geolocation technology to trace that address to a jurisdiction. This method is famously flawed. Virtual private networks, onion routing spoof IP addresses, routers and other devices are unsecured, malware cracks passwords and opens backdoors, multiple people share the same IP address, a geolocation service might randomly assign addresses to some general location. See James Temple, lawsuit says grandma illegally downloaded porn. Simply put, inferring the person who pays the cable bill illegally downloaded a specific file is even less trustworthy than inferring they watched a specific TV show. But in many cases, the method is enough to force the internet service provider to unmask the IP address subscriber. And once the ISP outs the subscriber, permitting them to be served as a defendant, any future Google search of their name will turn up associations with websites like Vixen, Blacked, Tushy, and Blacked Raw. Well, there goes our monetization. The first two are awkward enough, but the latter two cater to even more singular tastes. Little wonder so many defendants settle. Indeed, the copyright troll's success rate comes not from the Copyright Act, but from the law of large numbers. According to Pacer, over the past 13 months, Strike 3 Holdings has filed 1,849 cases, just like this one, in courts across the country, 40 in this district alone, the District of Columbia, closely following the copyright trolls who together consume 58% of the federal copyright docket in 2015. These serial litigators drop cases at the first sign of resistance, preying on low-hanging fruit and staying one step ahead of any coordinated defense. They don't seem to care about whether a defendant actually did the infringing or about developing the law. If a Billy Goat Gruff moves to confront a copyright troll in court, the troll cuts and runs back under its bridge. Perhaps the trolls fear a court disrupting their rinse, wash, and repeat approach. File a deluge of complaints, ask the court to compel disclosures of the account holders, settle as many claims as possible, abandon the rest. See Matthew Sagg and Jake Haskell, Defense Against the Dark Arts of Copyright Trolling. Here, that approach led Strike 3 astray. Because Strike 3's need for discovery does not outweigh defendants' privacy expectation, the court will deny Strike 3's ex parte motion to subpoena defendants' ISP to discover defendants' identity prior to the 26F conference. That sunders Strike 3's entire case, since a failure to identify defendant makes effectuating service impossible. The court will dismiss the case without prejudice. Now that doesn't mean that Strike 3 couldn't come back with what I talked about. They're smarter than me. They have many more lawyers than me. I'm not helping them by talking about this. They know that they could put more time and effort into each complaint, into meeting an actual pleading standard instead of trying to just get mass litigation through. But sometimes that's the strategy, is making the money grab while it's available and then backing off the moment that the heat starts coming on. It's a time-honored, timeless strategy. And unfortunately, large law firms like Fox Rothschild would know how to do that and would have the resources to do exactly this. I personally don't think it is ethical, but I'm not saying that it is unethical in the professional responsibility sense. I think that is worth investigating. So I'm not trying to defame anyone. The rule of law is written that copyright complaints can be made, and it is entirely possible that Strike 3 Holdings and their investigator IPP Limited really think they see infringement, and they just haven't met the pleading standard. That's not necessarily unprofessionally, like lose your bar license or get a bar complaint against you kind of thing. But I do think it's unethical in the why are you pursuing copyright claims in a way that isn't really advancing copyright law. That's the unethical part. It's to me it's a misuse of the law so much more than a misuse or violation of professional responsibilities. Strike 3 cannot subpoena defendant's ISP because its discovery lacks sufficient specificity and does not overcome defendant's privacy expectation. Strike 3's request for early discovery falls short of Rule 26's requirements. A plaintiff can only discover an unknown defendant's identity through a court order under Rule 26d1, but the rule cabins a district court's discretion to order discovery to circumstances where a plaintiff shows good cause. And to show good cause, the D.C. Circuit requires establishing likely personal jurisdiction. Here, Strike 3 clears that hurdle. CAF Holdings versus Doe's, a D.C. Circuit 2014 case suggesting using geolocation services as a good faith belief that they are in the correct jurisdiction. Yet the D.C. Circuit never said this was the only requirement. For one, the court must also balance Strike 3's need for discovery with a potentially non-infringing defendant's right to be anonymous. Only the Second Circuit has articulated this balance, looking to plaintiffs' showing of a prima facie claim of actionable harm, their discovery request specificity, their alternative means to obtain subpoenaed information, the need for the subpoenaed information to advance the claim, and the objecting party's privacy expectations. And it's citing a bunch of Arista Records cases. One can hardly blame the D.C. Circuit for its silence. Of the 40 cases Strike 3 has filed in this district, including 7 on a single day, none have reached the Court of Appeals, 22 have been voluntarily dismissed, all but 1 following the same formula. Strike 3 files a complaint, identical in every case except for infringing IP address. A few weeks later, Strike 3 files a motion to subpoena the anonymous defendant's ISP prior to the Rule 26F conference, identical in every case except for the ISP to be served. Satisfied by Strike 3's showing of likely personal jurisdiction, the court grants the motion, usually providing 20 days for the defendant to move to quash the subpoena, and sometimes providing for defendant's continued anonymity. Nothing happens for a few weeks, and then Strike 3 voluntarily dismisses the suit. And they cite a bunch of case numbers down here at the bottom. In the lone exception, case number 18-810 in the District of Columbia, the defendant successfully obtained the court's approval to proceed anonymously and appeared to be prepared to serve a responsive pleading, but Strike 3 dropped the case. The 18 pending cases are no different. In 12, the judge recently granted the early discovery motion and Strike 3 is waiting for the ISP to respond. In 5, Strike 3's early discovery motion remains pending, and in 1, Strike 3 hasn't yet filed its discovery motion. This sounds crazy, but it's par for the copyright trolling course. According to Pacer Malibu Media LLC, another adult film company has filed 150 cases against anonymous defendants in this district, 7,183 nationally from 2012 to 2018. Now, yours truly has represented about 750 of these cases, which means that I've represented in somewhere around 5 to 7% of the cases in the country in copyright law. Let that sink in when you see this. 5 to 7%. Although the D.C. Circuit has never had the chance to elaborate on its test, the undersigned considers the Second Circuit's test very persuasive, and not for nothing. It comports with the D.C. Circuit's more general observation when evaluating good cause under Rule 26. Interests in privacy may call for a measure of extra protection. Moreover, in determining which interests to weigh in the Rule 26 balance, courts look to statutory confidentiality provisions, even if they do not create enforceable privileges. In this case, the court looks to the Communications Act, which protects cable subscribers' names and addresses. Applying the Second Circuit's test and placing great weight on defendants' privacy expectation, the court will deny Strike 3's motion for early discovery. To be sure, Strike 3's alleged ownership of an infringed copyright sets forth a prima facie claim. So too is the requested information necessary to advance Strike 3's claim. But Strike 3's legal request lacks the type of specificity the Second Circuit's test requires, that the request will identify a copyright infringer who can be sued. In circumstances where the identity of alleged defendants will not be known prior to the filing of a complaint, I'm highlighting this for myself later, the plaintiff should be given an opportunity through discovery to identify the unknown defendants unless it is clear that the complaint would be dismissed on other grounds. Strike 3 could not withstand a 12b6 motion in this case without resorting to far more intensive discovery machinations, sufficiently establishing the defendant did the infringing. Examining physical evidence, at least computers, smartphones, and tablets, I can verify that that happens, as well as any neighbor or house guest who shared the internet, sometimes that happens, and perhaps even interrogatories. I haven't gotten there with Strike 3 yet. Document requests or depositions. We have submitted declarations or affidavits or documents to defend. Strike 3's requested subpoena thus will not, and many never will, identify a defendant who could be sued. Similarly, even though defendants have little expectation of privacy in downloading and distributing copyrighted films without permission, Strike 3 fails to give the court adequate confidence that this defendant actually did the infringing. Given this uncertainty, Strike 3 cannot overcome defendants' weighty privacy expectation. Imagine having your name and reputation publicly and permanently connected to websites like Tushy and Blacked Raw. Google them at your own risk. How would an improperly accused defendant's spouse react? His or her boss? The head of the local neighborhood watch? The risks of false accusation are real. The consequences are hard to overstate and harder to undo. And Strike 3's flawed identification method cannot bear such great weight. Defendant may not be entitled to the same presumption of innocence a criminal defendant enjoys, but the court remains uncomfortable publicly presupposing defendant partook in particularly prurient pornography given defendant's tenuous connection to the infringement. There is a different presumption of innocence in civil court. It's called preponderance of the evidence, and it's a 50-50 or a tug-of-war standard. Whoever wins a tug-of-war while adhering to legal process and argument and evidence and all that, they win. Whoever's more convincing wins. There's nothing really more to it, aside from it being within a legal framework and it needing to adhere to that. As long as the judge is convinced, you win. If the judge can articulate that, even better, probably survive appeal. Since Strike 3 Holdings' discovery request lacks the required specificity and does not overcome defendant's privacy expectation, the court will deny Strike 3's motion for early discovery. Though Strike 3 admits a protective order could allow defendant to anonymously challenge the subpoena, that hardly seems fair. That drags defendant into court, foists on them the unenviable burden of hiring a lawyer or defending their reputation pro se, all before they've even been served. That's not how our system of litigation is supposed to work. Moreover, the inconsistency with which courts permit defendants to proceed anonymously illustrates the ineffectiveness of this shield more generally. An honest copyright holder might balk at this result, misunderstanding it to slash congressionally endowed defenses against increasingly creative and covert cyber pirates. But the typical case does not involve pornography, nor is this even run-of-the-mill porn. By extension, two factors limit today's holding. First is this content's aberrantly salacious nature. So this means this applies to salacious content more than anything else. That means this applies to adult entertainment lawsuits. This doesn't apply to Sony suing over music or Disney suing over movies or, I'm making those up, but, those are two large litigants. So that's still allowed to go on. This is saying when you have this salacious nature of the content, that there's this extra level of protection, at least in DC, and guess what? I said I was involved in 5 to 7% of the cases. That means that I will begin offering to my clients the opportunity to challenge where we will cite this, because this looks like very good grounds to go into court and fight every single one of these cookie cutter copyright troll cases. Second is the legion pitfalls associated with the Strike 3 holding tracking and identification method for their infringers. Given these high stakes, unlikely to appear in more typical cases, the court will not accept the risk of misidentification. Maybe someday someone will show the court a method to identify infringers with sufficiently less risk of false accusations, but because Strike 3 fails to do so here, it cannot subpoena defendant's ISP. Because Strike 3 cannot effectuate service, its case must be dismissed. Denying Strike 3's discovery motion dooms its claim. Simply put, Strike 3's inability to identify defendant makes effectuating service or prosecuting the cases impossible. So because Strike 3 cannot proceed with its claim, the court must dismiss it. Strike 3 does not dispute this logic. It concedes defendant must be identified before the suit can progress. But without information from the ISP, Strike 3 admits it cannot correlate the infringing IP address to its subscriber and identify defendant as the person assigned that IP address. And so Strike 3 cannot name and serve those whom they allege to have infringed upon their copyrights. Strike 3's lone rebuttal points out that the courts have rejected the dismissal of suits against unnamed defendants until the plaintiff has had some opportunity for discovery to learn the identities. But as this opinion has already explained, this case is exceptional and limited as Part 1 describes. Because Strike 3 chases a dead end, the court will deny as moot Strike 3's motion to extend the service deadline and dismiss the case. Armed with hundreds of cut and pasted complaints and boilerplate discovery motions, Strike 3 floods this courthouse and others around the country with lawsuits smacking of extortion. It treats this court not as a citadel of justice, but as an ATM. Its feigned desire for legal process masks what it really seeks: for the court to oversee a high-tech shakedown. This court declines. The court denies Strike 3's ex parte motion for discovery prior to the Rule 26F conference. Since this makes serving the defendant impossible, the court denies as moot Strike 3's motion extending time to effectuate service, and then dismisses the case without prejudice. An order will issue. We looked at that before. So that's epic. Absolutely epic. That will likely change the sea of copyright litigation that is currently going on in the federal courts with Strike 3 Holdings, Fox Rothschild, Malibu Media, and Lomnitzer, which is their representation. And just so you get a chance to see what in the world we're talking about, this is the exhibit that was listed in this complaint. There's 22 infringements in this complaint, and they list in UTC what the date of alleged infringement was, and then they list a copyright number. I believe it's the it's the PA numbers are the applications, and the not PA numbers are the registrations. I think that's how that works.
I believe the not PA is the applications, and then PA stands for performing arts.
Oh, okay.
So those are the actual registration numbers.
Okay. I have one sitting back here we can check. I have one of my own copyright registrations so we can see what they look like. And they only really they don't even have titles here. I'm sure that they have titles, but they're not listing them. They just list alleged lines and say, an IP address downloaded this computer file, which could be enough if then their complaint met the Rule 8 pleading standard, at least for this particular court. And so what's happening here isn't that all these cases suddenly stop. And I got to make sure that I bookend this for my clients as well. And I guess I should also say that this could be considered attorney advertising since I do practice in this area. But this order does not mean that these cases stop. It means that this case stops. It means that cases before Judge Lamberth will need to be pled to a higher standard, or they just stop. And that other defense attorneys around the country, like me, will use this order and memorandum and cite this and encourage defendants to fight Strike 3 Holdings here. Let me bookend this. The trouble then is, what if they're right? What if they're suing you and you are the defendant and the subscriber and you did do the thing and all that? You can still use this, but your attorney probably should be telling you that if you do this and they do file something that finally does meet the pleading standard, they could just keep going. This does not dismiss the claims as if they've been adjudicated. It dismisses the claims as in they haven't been procedurally presented correctly. So it says without prejudice. And this is very important, because without prejudice means that the case and claims can be filed again. They are not extinguished. They are subject to a statute of limitations. So if anything in that list was old, over 3 years old, That would be kind of moot if they had to bring a new case now. But otherwise, they can bring a new case. They can try to meet the judge's pleading standard, try to overcome this memorandum opinion, and continue about the cases. And this is how Malibu Media has gotten as far as they've gotten, is they've more or less done that. Whenever they've been challenged on this level, they have refiled new documents in new cases that have more details. I'm not sure if Malibu Media is also affected by this yet. I need to take a look at, and I've asked TAC actually to look at a Malibu Media complaint and see if they're doing a better job of it. And I don't know, do you have anything to report, TAC?
I don't see any level of specificity. I don't see anything different from Strike 3 Holdings. I think that they would be, my non-lawyer opinion.
Yeah, we're non-lawyer opinion is fine. You work for me.
Is that the same standard would apply to Malibu Media? Because mostly they just say, we have investigators reported this IP address, therefore we're suing this IP address. Give us the name.
Yeah. So I'm currently in court on 3 different federal cases right now, 2 of which I can't talk about, and one of which is the Louis Rossman case, and I can talk about that. But you can definitely be sure that we will make this event information available to our clients, our prospective clients. We will post a video about this and make sure that the world knows as much as possible that they can fight these cases using this. It doesn't mean that everybody's going to. It doesn't mean that copyright trolls are going away yet, but it is possibly a turning of the tide in one major battle. So we'll see what happens.
And I think people need to understand that these cases, you can sort of look at Strike 3 Holdings and be like, okay, wow, they filed, more than 1,000 cases in a year. And think about Strike 3 Holdings, but you as a defendant, you come home, you receive a letter from your ISP that says you're being sued for downloading these movies, and we have to release your identity. And when you might call up Strike 3 Holdings and say, hey, wait a second, no, I got a notice, but I didn't do this. Well, now Strike 3 Holdings has your identity ahead of time, and now they're telling you, well, if we went to court, we would get $2,250 per infringement. Once we prove that you've done it.
That's a good. Let me interrupt you for just a moment. That's a good bookending of this. Let's go back to that list. When you're looking at this list, which I now can't scroll again, I don't think. Hang on. I can scroll to the other page. When you're looking at this list, there's 22 items on this list. And statutory damages in copyright infringement means that if they have this registration over here, if it is valid enough for the court, that allows them to obtain damages set by law instead of having to conduct an investigation and make arguments as to what the actual damages are. If somebody downloads a movie online without paying for it, what are the direct copyright infringement damages? We're not talking about contributory or sharing or anything, even if that happened. That's not the damages we're talking about here. For the direct actual downloading of copyright material, what are the actual damages? The profits on a movie? So $20. And so what courts do then is if the actual damages were whatever, $20 or $1,000, whatever, if the infringement could be proved to be willful in tort law, we normally multiply by 3. So the damages become $60. Or if it was $40, they become $120. But instead, copyright statutory damages are $750 per title or per infringement at the minimum level. Then times 3, so you get $2,250 each. For 22 infringements, if this was a client calling me, I would be telling them, you're facing a $50,000 lawsuit, plus their attorney's fees. Now, I try not to scare my clients into settling their cases, but many of my clients settle their cases because they can't, pretty much exactly what the judge said, they can't either afford financially or afford emotionally or afford family-wise to go through with this kind of lawsuit. And it is a great disparity of power between the plaintiff and the defendant, and yours truly tries to be an equalizing force in the world. And at times we have been able to do so, but at times we also have to settle cases to get rid of them because that's what our client wants to do. So it is kind of a terrible extortion racket. I can now go on publicly say that a judge has said it is an extortion style thing, and that they are copyright trolls according to Judge Lamberth, Royce C. Lamberth. So I can go on record and say they are a copyright troll according to Judge Lamberth. Their method is flawed. They run back under their bridge, and legion pitfalls, which I'll have to remember that word now as a substitute for many. But
I mean, there's like, we are legion, right? That's a thing. So I don't know
we are many. I guess that's what it sounds more sinister than it actually is. So the two things to take away from this are that when you have a BitTorrent style copyright lawsuit over copyright material of an aberrantly salacious nature, there should be an extra layer of scrutiny in the identification of the infringer before they are allowed to subpoena an ISP and get a subscriber's name and start that process. So what do you think of that, my lawful masses? That is pretty remarkable. I'm literally going to take that information and incorporate that into my own law practice. I will be advising clients about that case and fighting Strike 3 holdings and Malibu Media wherever I can.
What happens if the infringer is, a teenager and is, Kotaku said 12, but let's think like a 16-year-old.
Sure.
Is the infringer and not the actual internet subscriber, which would be the parents.
Yeah, laws vary from state to state, and so whenever we get this question, we have to look up the local laws and all that. The local law will say something about how much money, if any at all, a parent is liable for the wrongdoings of their minor children. Usually, this is also a bit of state law, but usually even the minor child isn't that terribly liable for their wrongdoings under most state laws. One of the ones we've dealt with recently was New Jersey. And New Jersey has no parental liability for the torts of a minor child for most civil private offenses. And they have a listing of public offenses against like schools and stuff like that, where the parents can be held to a certain monetary amount of damages if the child vandalizes the school or whatever. In Pennsylvania, I believe it's $2,500. The parent can be liable for up to $2,500, but nothing more. So when we've gotten that case in the past, we have shut down that case by offering somewhere around that amount of money to make the whole case go away. Yes, and that works out especially well if it's a large case or something, and if the infringement is actually something we've been able to verify. But, we can't always verify it, and not everyone wants to pay to verify it, so we have to kind of decide on a case-by-case basis when it's worth it and when it's not. That is our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney, and this is Nico the dog. And he also is back there someplace, on the right side of the screen, giving me the whale eye. Side of your eye. Thank you very much to our Patreon supporters for the month of November, not the least of which is Justin Rogers, sponsoring at the $500 level. Thank you very much, Justin. At the $50 level, we have Jonathan Doe, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Andy, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, Terry Crisp, Richard Fournier, aka Breakfast Demon, Spirit Bear, Jan Negrey, and JAXMerrick. I did update the panel behind me for the $5 plus supporters. Thank you very much to the approximately 200 of you that are sponsoring our channel at that level as well. Hup. Come on. Hup. Good boy. So thank you very much for joining me, everyone. It has been a great show today. We talked about the Strike 3 Holdings thing, which I think is going to be our first case that we put out. That's a really remarkable thing and could actually lead to true change in the copyright landscape for those cases. So who knows where that's going to go. Oh, you're such a good boy. I love you so much. And this is called Reality by AGST. If you haven't seen, we had the Veterans Day video that was released on the 12th, I believe. It was a very nice ceremony, and I think I did a great job on the edit. I would love to hear what you think about it. Go check that out on the YouTube channel. We also released a time-lapse of the snowstorm that we opened this stream with. That's on the YouTube channel as well. Thank you very much for joining us there, watching that and all that. I love you all. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop this week. I believe we're working on Cambridge Analytica, and I think it will actually be done this week because it has been whittled down to 2,500 words, which is much, much more doable on a stream. So everybody in the US, have a great Thanksgiving week here. Look forward to my annual drone video. We'll see if we can get that done. And, of course, that will include our friends Nico and Ilsa. So, last time, I love you all. Have a good day. See you later.